Okay, I think we will go ahead and start. So again, welcome to all. I'm Randy May, president of the Free State Foundation, and I want to welcome you once more to today's program, which we've called Hot Topics in Copyright Law and Policy. That's admittedly a broad title, so we can cover a lot of ground. We're free to roam. In just a moment, I'm going to turn the mic over to my colleague, Seth Cooper. Seth, as most of you know, is Senior Fellow and Director of Policy Studies here at the Free State Foundation. But before doing so, just a couple more words of introduction. Here at the Free State Foundation, I think it's fair to say that we spend more of our time and resources on communications law and internet policy than we do any other type of work. But it's also true and important to say that intellectual property, and specifically copyright, is a really important part of our work as well. We believe here at the Free State Foundation that protection of property rights is important in terms of maintaining a prosperous, creative, and free society in which private enterprise thrives. And of course, intellectual property rights and copyright are property rights. And so we consider this an important part of our work, and work that not only do we put a lot of effort into, but we enjoy at the same time. I want to just mention, or actually maybe more than mention, actually push or make a sale or two for two books that we published on copyright. And of course, again, Seth played a major role in putting together these two books. The first one that I'm holding up is The Constitutional Foundations of Intellectual Property and Natural Rights Perspective. You can see I've got a couple tabs on this one. Almost all of my copies have these tabs. This book really, I think, goes into the historical, jurisprudential, constitutional background for securing property rights. And, I think you come away with a good sense of why the founders included the intellectual property clause in the Constitution. It starts with John Locke and works its way up through Madison, Noah Webster, let's see, maybe even Daniel Webster, Joe Story, and right up through Abraham Lincoln, and really contains, I think, a lot of good background information on why copyright is important in our constitutional system. Second book I'll just mention, this one here, is Modernizing Copyright Law for the Digital Age, subtitled Constitutional Foundations for Reform. This picks up a bit where Constitutional Foundations left off and examines some of the post-Civil War history of copyright development and deals with some of the modern day issues that we deal with today, especially, again, from a philosophical, foundational point of view. Okay, the last thing I want to really say, before I turn it over to Seth, we have a distinguished panel here today, but I especially want to take note and thank Adam Mossoff for being there. Adam is a member of our board of academic advisors here at the Free State Foundation. We're grateful for his participation as part of that board. And, it's fair to say, without any fear of contradiction, that Adam is one of the leading scholars in the nation in this field of intellectual property at a fairly young age. You know, from my vantage point, it's a young age. Adam has already distinguished himself and forever as one of the country's foremost scholars in the field of intellectual property. So thanks for Adam being here in addition to the others. So finally, I'm going to just remind you to tweet for those that wish to. It's hashtag FSF copyright is the Twitter handle. So with that, I'm going to turn it over to Seth. Take it away, Seth.
Well, thank you, Randy. Thank you to all the members of our audience for joining us today. We have an opportunity to hear from some top-notch scholars on intellectual property, to hear about some really current topics in copyright law and policy. Randy had mentioned our book, Modernizing Copyright Law, where we tackled some of these modern issues, but sometimes you actually get some reforms accomplished. And some of the reforms we'd advocated in our book have come to pass in terms of increasing the penalties for streaming, illegal piracy. The Music Modernization Act did some other things. But then you have a number of other issues that have been around a long time, but then they start to bubble to the surface now. And so those are some of the things that we'll get to discuss today, some of the copyright issues that are current, that will be in the news through the later part of this year and most certainly into next year. And so I'm going to introduce today's speakers. We will hear from a little bit from each of them. And after that, I'll direct some questions to our excellent panel. And as we go along, if you in the audience have any ideas for questions, you can certainly offer those and we can make some time to present some of the questions from the audience to our speakers. So to introduce our panel today, we first have Jessica Richard. She serves as Vice President for Federal Public Policy at the Recording Industry Association of America, where works the intersection of law and policy, and she engages with policymakers on issues affecting the music industry, and advances the interests of RIAA in the music industry at Capitol Hill, and also interacting with other third parties and outside experts for purposes of advocating for creators' rights and freedom. Now, before joining RIAA, Jessica practiced law for nearly 8 years at Williams & Connolly LLP, specializing in commercial litigation and intellectual property, and she's a graduate of Dartmouth College and the University of Michigan Law School. The next panelist we have for today will be Devlin Hartline. He's a legal fellow at the Hudson Institute's Forum for Intellectual Property in Washington, D.C. His research includes a focus on advancing and protecting the rights of creators and innovators. And prior to joining Hudson, Devlin was assistant professor of law at George Mason University's Antonin Scalia Law School, where he taught subjects including copyright and other intellectual property subjects. He also served as the director of communications at the Law School Center for the Protection of Intellectual Property. And Devlin holds a law degree from Loyola University. Actually, that's a master's of law degree from Loyola University. You know, actually, Devlin, which one is which? Loyola University is the law school, and you have a master's of law degree as well. Was that Tulane? I think so. Okay, and then he's got a bachelor's from the University of Colorado at Boulder. So we're delighted for someone like Devlin, who is just all over every copyright issue imaginable out there. We're delighted to have him here today. And then we've also going to hear from Adam Mossoff, who's professor of law at Antonin Scalia Law School at the George Mason University, and he teaches a wide range of courses, including intellectual property topics. And his work has been cited by the Supreme Court and U.S. Court of Appeals for the Federal Circuit. You'll find Adam filing amicus briefs, and it seems to be many key intellectual property issues, including particularly patent issues, and certainly is published in popular presses like the Wall Street Journal, New York Times, Forbes, and the rest. Adam graduated from the University of Chicago Law School. He holds a Master of Arts in Philosophy, specializing in legal political philosophy from Columbia University, and an undergraduate degree from the University of Michigan. So I'm glad to have everyone here today. What we'll do for this panel is first I'll be hearing from Jessica and Devlin. They'll each take some time to be discussing some issues. some very specific copyright law and policy topics. And after that, I will turn it over to Adam to offer just some general or responses or whatever insights he has to offer that strike him at the time. So Jessica, the floor is yours.
Thank you. And thank you so much for having me here. It's a pleasure to be on this panel with you. I so appreciate the invitation and being in such great company. As Seth mentioned, I work at the Recording Industry Association of America, a trade association in DC that represents the major record labels. Those are Warner Music Group, Universal Music Group, and Sony. And our issues that we work with day in, day out frequently revolve around copyright. Because that's, of course, what allows the business to flourish, what securitizes the music that then is spread throughout the world to fans today at the click of a button, wherever, whenever they want it. And the issues that I want to focus on today are kind of some of the evergreen hot issues in copyright. So I'm going to start generally with DMCA reform, where we are now and where we think it's going. So I am sure that everyone who is watching or listening to this is familiar on some level with with the DMCA and how it has been applied over the last 20 years. But it's helpful to kind of put your mind back then to frame the discussion and illustrate how times have changed, how maybe the markets have evolved and technologies have evolved in ways that weren't anticipated in 1998. So, the DMCA, I plan to focus on Section 512, which creates the notice and takedown system. Everybody knows about it. It's a grand bargain between online service providers and content copyright owners, whereby a copyright owner has a mechanism that they can use to have infringing materials removed from websites that are hosting user-generated content. And then those websites, if they follow a series of steps outlined in the law, are eligible for safe harbor protection from liability for those infringing works that are posted to their sites. So Congress envisioned this grand bargain back in 1998. So the DMCA was passed into law within 30 days of Google's founding. So there was no Google until shortly after the DMCA became law. And now, of course, Google with YouTube is one of the biggest users or participants in the 512 system that the DMCA created. Likewise, in 1998, most of us didn't have cell phones. And if we did, we used them to call people and not to access every kind of piece of information and media that we want all the time from anywhere in the world instantaneously. That's a big change. And download, upload times, if you wanted to download something to your computer back then on your dial-up modem, it probably took all night, and now you just push that button and it's out for the world to see that minute. So the evolution of technology since 1998 has been staggering and has been fantastic for the spreading of information, but also has exposed some weaknesses in the legal framework that just either weren't accounted for or the law hasn't developed in a way that's really kept up with the technology. And in my view, applied the law in a way consistent with Congress's intent. So it's not just, technologies that have changed so much. It's also the market for copyrighted works, including most, music for my purposes. We went from a fully physical market back in 1998 that peaked, was fantastic for the music industry in 1999 to being cut in half in the first decade of the 2000s. And now we're having growth again in the streaming environment, which didn't exist at the time. So the market has undergone tremendous changes, and user-generated sites or sites that host user-generated content are among the most popular for consuming music now. So those are sites that can have safe harbor eligibility if they follow the rules, making the DMCA all the more important to, health of the ecosystem. So the problems that emerged over the 20 years largely are due to scale, just, what used to be a more manageable amount of infringing material and much smaller universe of material, period, online, has grown so much that we're in a situation where there's millions of infringements on these sites every day, millions of takedown notices being sent, and then they go right back up. So it's just a constant churn of infringement and removal that's hard to keep up with. It's hard to manage, no doubt, for service providers and certainly for copyright owners, on whom much of the burden is placed under the DMCA for finding their works and sending the notice, which also leads to courts frequently having interpreted the Section 512 in ways that lower the obligations on service providers and then increase the corresponding burden on copyright owners. And this was recognized by Congress, recognized by the Copyright Office, so in 2020, the Copyright Office put out a big years-long product of a years-long investigation and study report on Section 512 of the DMCA. And one of their main conclusions was the balance is askew. What was supposed to be this kind of mutually beneficial system is really putting more onus on copyright owners. And there might be some ways to recalibrate that and rediscover that original balance. But as currently interpreted and applied, this law is not really doing what it was supposed to do. And then in Congress, there was a series of hearings over the course of more than a year, delving into the findings in the Copyright Office report, also seeking all kinds of stakeholder feedback and testimony, which resulted in some draft legislation contemplating all different ways and areas in which the law could be improved. Like I said, based on inputs of stakeholders on every side of the issue. And since then, there's kind of been a filtering effect, and one particular issue has stood out as what might be the most promising avenue forward in terms of DMCA 512 reform, and that's standard technical measures. So there's been a lot of emphasis on STMs, as we call them, because everything has to be shortened and abbreviated. A lot of talk about them over the last, I'd say, 18 months with the Copyright Office, having initiated some stakeholder roundtables to discuss what's happening with them, why they're not used. But as a background to that, STMs refer to Section 512I of the DMCA, which you may not be familiar with because it isn't used currently. So what this says is a standard technical measure, and a service provider has to accommodate and not interfere with a standard technical measure to be eligible for the safe harbor. And safe harbor eligibility is critical. So this is a very important provision. But what a standard technical measure is then defined to be is a technical measure used by copyright owners to protect and identify their works online. And for it to be a standard technical measure, there has to be a voluntary open standards process in which stakeholders agree that something is a standard technical measure. And the problem with this provision is the incentives aren't aligned, because essentially it's saying you need service providers to participate in a voluntary standards process, the outcome of which could be additional obligations on them, things they have to do lest they lose the safe harbor. So if they don't participate in this voluntary process, that's not going to happen. They don't have the risk of these additional obligations that could threaten their liability shield. So they don't have the reason to come to the table for the establishment of that type of standard technical measure. And, our hope, we always think market-based solutions are ideal, they're flexible, they're durable, but parties need to come together to agree to those voluntary solutions. So we remain hopeful that there can be more progress made toward development across, the market or use across the market of these technologies that already exist and that most people are already using, so that stragglers who choose not to use them can't game the system and deprive copyright owners of their help and put their competitors at a disadvantage because they're not doing what they should be doing. So, in the absence of any voluntary solution to date, there has been a bill introduced by Senators Tillis and Leahy called the SMART Act. And this bill approaches the issue in two different ways. One of them is making modifications to Section 512. So that, like I said, deals with the safe harbor eligibility. And the other is to create a whole process under a new Section 514. So under 512, the changes that are tied to the safe harbor, that affect the safe harbor, the law, or the bill rather, kind of attempts to lower some of the burdens to establishing a standard technical measure, but doesn't really realign the incentives. So in terms of the burdens, it does say that it redefines a standard technical measure as one used not just by copyright owners, but also by service providers to identify and manage infringements or copyrights online. So that's more clearly placing an affirmative onus on the service provider than in the original 512I language. It also requires broad consensus, not of the entire world, but of the relevant community of stakeholders in order to come to agreement on what a standard technical measure might be. And it doesn't require a formal standards process. It allows an industry process, which might be less formal. So it lowers those bars, but notwithstanding, it still requires voluntarily coming to the table in order to agree a standard technical measure. I'm very interested in the second part, the Section 514, which creates a new process that allows the Librarian of Congress and the Copyright Office to designate a standard technical measure. So this is outside of 512. Safe harbors aren't on the line, and it's got a different term, DTMs, designated technical measures, instead of standard technical measures, because they have different qualifications. So what happens here is there's a triennial rulemaking process that would be established under the Copyright Office, akin to the 1201 triennial process for anti-circumvention. And in this process, the Register of Copyrights and Librarian would take petitions from stakeholders, be they copyright owners or service providers or developers of these products, that describe what the technical measure is that they would like to see designated and to whom they believe it should apply. And then the Copyright Office would undertake their own investigation and consideration of the issue, really looking at the market, seeing what's out there, seeing, is this the type of thing that everybody's using except for these few holdout stragglers? Does it, what are the costs? There's lots of factors that they're told to look at. What's the scale of infringement that these would address? What are the effects on fair use and competition and cybersecurity and privacy? And are there any groups of service providers that ought to be exempt because they don't have infringements on their sites? It asks the Copyright Office and Librarian to consider all of these things, and then it consults with other agencies who might have expertise in the particular technical measure, how it's applied, or in cybersecurity or so on. And then it can determine whether something is a technical measure, a designated technical measure. And if it is, for purpose of this section, the term accommodate, which is also used in 512I, but is then repurposed in this section and given its own definition for purposes of this section, and it means to implement. So it means that service providers actually have to take the steps to implement a designated technical measure, or they could face civil liability. And so the bill also provides that damages and injunctive relief could be available for failure to accommodate, i.e. implement technical measures. And in this way, it accepts kind of the involvement of everybody, all the stakeholders out there who have skin in the game. It asks them to participate, to give input, to inform the Copyright Office's decision, but it also doesn't empower holdouts and kind of reward them for not doing what they ought to do and what all of their peers are doing, or not using the technologies they already have for these purposes. So it's a helpful bill to have been introduced because it shows, that if voluntary cooperation isn't obtainable, that Congress, I hopefully will be willing to do something to correct it. And hopefully it doesn't come to that. But if it does, this is one avenue where there could be progress, and these ideas could form the basis for an improvement to the law that would help copyright owners of all kinds to protect their works in this, massive digital ecosystem where technologies already exist and are used that can make the process so much easier. So that is what I have to say on DMCA reform as of end of July 2022.
Well, thank you, Jessica. Thank you for tackling a very complicated subject and doing so well. I'll next turn to Devlin Hartline, who's with Hudson Institute, and be glad to hear from you, Devlin.
All right. Thanks, guys. And sorry about earlier, Seth, when you asked me a question. I was trying to unmute, but I was having technical difficulties. I don't know what's going on, but it appears to be working now. So fingers crossed that it keeps working. And first of all, I just want to thank Randy and Seth and the Free State Foundation for hosting this event. I'm excited to be here talking about copyright law and policy, which is my favorite subject in the whole world. I actually spent the last 2 days taking the bar exam in DC. And so I've spent the past several weeks thinking about things that aren't copyright law, and it's been kind of miserable, but the exam is done. And I feel good about it. And so now I finally get to turn back to something that I actually want to think about. And so what I want to talk about today is something which is a very hot topic right now in copyright law, and that has to do with ebook licensing. But before I get into that, I think I need to give some background information. So copyright law is constantly evolving as technology advances and people figure out new ways to distribute and enjoy copyrighted works. The move from physical media to streaming services has been wonderful for consumers. Instead of buying physical copies of all of our favorite content on CDs, DVDs, or books, we can now access all of that content online on demand. And so in my house, for example, we use Amazon and SiriusXM for music, Kindle and our local public library for ebooks. And we subscribe to several streaming services like Netflix and HBO Max for television shows and movies. We have access to literally millions of works at the press of a button for what is a very reasonable price. It's really quite amazing. And many of these services even allow users to download content to enjoy offline, just in case they don't have access to the internet. These advances in technology have led to new business models and opportunities for copyright owners to connect with their fans. But they have also made it easier for less scrupulous people to infringe copyrighted works on an incredible scale. And moreover, some of these services raise serious questions about copyright owners not getting paid fair market value for their works. This is especially true in the music industry, where there are compulsory licenses and the government sets rates. So for example, you can subscribe to Spotify for about $10 a month, which to me seems insanely low for what you get. But that's a different avenue. But even though consumers have all of this wonderful content available at a great price, some people still complain that it's not enough. And this is especially true when it comes to ebooks, which are digital versions of physical books that can be read on a phone, a tablet, or a computer. And there have been recent concerted efforts to weaken the rights of authors and publishers when it comes to the licensing market for their ebooks. The two most prominent examples of recent time are state compulsory licensing and the so-called practice of controlled digital lending. And I'll talk about both of these today. Both of these efforts use our sympathies for public libraries, who doesn't love their public library, to push for what is actually a radical change to copyright law. But to understand what's going on here with ebook licensing, we first have to talk about the first sale doctrine. So under copyright law, copyright owners have several exclusive rights, including the right to make new copies and the right to distribute copies. The first sale doctrine, which is codified now in Section 109 of the Copyright Act, provides that copyright owners can only control the first sale of a particular copy. So once a lawfully made copy is distributed to the public through a sale, the copyright owner cannot control further downstream distributions of that particular copy. So we say that the copyright owner's distribution right has been exhausted as to that particular copy. And it's because of this first sale doctrine that people can sell the books that they own and libraries can loan out the books on their shelves. But as I noted earlier, the world has been moving towards digital distribution models and away from physical copies. So instead of buying physical books, many people are accessing digital ebooks online. And that content is generally licensed, not sold. And so this has profound implications for the first sale doctrine. Since people do not own physical books under these services, the distribution right of copyright owners has not been exhausted. And so even in a situation where someone does own a digital copy of an ebook, that person cannot sell or loan that copy online. And the reason for this is simple. When you transmit a file over the internet, new copies are necessarily made. And while copyright owners that have a distribution right that may have been exhausted, they still have a reproduction right that has not been exhausted. And so this is the issue that we're seeing. And so it should be noted too that even if you happen to own a digital version of a work, that doesn't mean that first sale doesn't apply. For example, if somehow you had a lawfully made copy on a thumb drive, rather than upload it to somebody over the internet, which would create a new copy, you can sell that thumb drive with the work included on it. So first sale still exists. The problem is transmitting things over the internet because you get new copies. And so, in other words, while there's certainly the first sale doctrine for physical copies, there is no digital first sale doctrine when we're talking about transmissions over the internet. And this simple fact has been recognized for decades, although there are certain people who just don't like it. And so how do they react? They've been reacting in one of two ways. Either they argue that we need to change the law, or they pretend that the law isn't the way it is. And so that brings us back to ebooks. And so the first issue I want to talk about is state compulsory ebook licensing. And this is an example of where proponents of digital first sale would like to change the existing law. And that sounds great. The only problem is they're going to the wrong lawmakers in order to change the law. They're going to state legislatures instead of to Congress. And so what happens here? When a library loans out physical books to patrons, that is covered under the first sale doctrine. But more and more patrons are asking for access to digital ebooks, and they're turning to their libraries for this. And so, as I mentioned earlier, when you distribute something over the internet, it necessarily makes a new copy. So the first sale doctrine doesn't apply. So what libraries do instead is they obtain licenses from authors and publishers that allow the libraries to in turn further distribute the works online. Of course, it is fundamental to copyright law that the copyright owners can set the terms under which these new copies get made when libraries lend out digital versions. And so say, while a consumer might be able to get a personal, non-commercial, private use license from Amazon for a particular ebook that may cost, say, $10 or $15, when the publishers go to libraries, they charge more than that. And why? Because the libraries are going to turn around and distribute it to dozens of people. And so this is to be expected. Libraries aren't getting a license for their own personal private use. They're getting a license that lets them distribute this book to their patrons. And so, in other words, these libraries are not like Amazon's customers. They are like Amazon itself. And so proponents of digital first sale complain and they say, this is completely unfair to libraries. Libraries have limited budgets and they shouldn't be forced to pay more for these licenses than you and I would pay if we went to Amazon and licensed an ebook. But what they fail to acknowledge is that we're not talking about the same kinds of licenses. The license I get is just for me to read the book. The license the library gets is to let lots of other people read the books. And so what have they done to remedy what they consider to be this unfair discrimination in the marketplace? They've turned to the states and said, please pass these compulsory licensing laws for ebooks. And so the state of Maryland passed such a law. It went into effect on January 1st of this year. And it says that if a publisher offers an ebook license to anybody in the state of Maryland, then it must offer a license to libraries and that it must be on terms that the state finds reasonable. Of course, what these proponents think to be reasonable is that libraries pay the same amount as regular consumers, ignoring the fact that these two situations are fundamentally different. But more importantly, this flies in the face of federal copyright law. So under our system of government, federal law trumps state law when the two conflict because federal law is supreme under the Supremacy Clause. And so lawyers call this preemption. And it comes in two different varieties, express preemption or implied preemption. But the result is the same. So there is express preemption in the Copyright Act. Section 301 expressly preempts conflicting state laws. But then judges can also say, hey, state law conflicts with federal law, and so it's implicitly preempted. But either way, the federal law is going to win. And so when you look at what these state laws are trying to force publishers to do, you can see that under either type of preemption, that it is preempted by federal law. And why? Because publishers and authors have the exclusive right under federal law to distribute the works on their own terms. So they can choose to license their works on whatever terms they want, or they can choose not to license their works at all. And so what these state laws do is punish a publisher for exercising rights that they have under federal law. And so the law in Maryland that was passed earlier this year was challenged by the Association of American Publishers, and they easily won their case, I think last February. They got a preliminary injunction. And the district court held that compulsory licensing of this kind, quote, stands as an obstacle to the accomplishment of the purposes and objectives of the Copyright Act. States can't come in and rebalance things where Congress has already established the balance. And so the fact that copyright owners get to choose how and when their works are distributed, this isn't a bug of the copyright system. This is literally its main feature. Unfortunately, other states have been considering similar legislation to Maryland's Compulsory Act. But after this resounding defeat, which, by the way, Maryland is not even appealing, there is hope that maybe these other efforts are going to be abandoned. And so it seems that if anything, that these proponents of compulsory licensing are probably not going to give up. They're probably going to have to take this fight up to Congress, where preemption would not be the same problem, right? So Congress could pass a law, and it has done so in the music ecosystem, forcing compulsory licenses to libraries if it wanted to. Of course, then we're going to talk about whether or not it should, and for reasons we can get into later, I feel like I'm going on for a long time. It's a really bad idea. And so that is the proponents of digital for sale trying to work at least to change the law, even though they're going to the wrong lawmakers. Now, there's something that's more pernicious that's happening right now, and this is the theory of controlled digital lending. And here, rather than acknowledging that the law needs to change, they're just pretending that the law already favors their extreme position. And so controlled digital lending, or CDL, it's a recent theory whereby libraries can take the physical books on their shelves, digitize them, turn them into ebooks, and then share those digital copies with members of the public. And so the biggest proponent of this theory is the Internet Archive, which was sued in 2020 by several publishers after it removed some of the restrictions that make controlled digital lending control. And so under the original CDL model, libraries had to maintain a 1-to-1 ratio of digital books that were loaned out and the physical books on their shelf. So if the library had 2 physical books on the shelf, it could loan out 2 digital versions. But once the pandemic hit, Internet Archive said, not going to follow this restriction anymore, and we're just going to loan out as many copies as we want at the same time. And so that was the final straw for publishers. And so they sued. And so what's going on here now is that the supporters of CDL argue that the practice is non-infringing under the first sale doctrine and fair use. So the first sale doctrine is a non-starter, right? Because new copies are getting made. Internet Archive is first taking a physical book and making an ebook, that's a copy. And then they're distributing it over the internet, which makes more copies and also implicates other rights, but it implicates a lot more than the distribution right. So to argue that this is somehow for sale is a non-starter. And so primarily they're arguing that it's fair use, but fair use should be thought of through the lens of the principles behind for sale. And so Internet Archive has copied millions of books that are in copyright, and then it just shares them online for free. And so we've seen courts, particularly the Second Circuit in the Authors Guild cases, have blessed this kind of mass digitization before, but those cases were about copying millions of books in order to make a searchable database that would return at most snippets of text and information about the books. And so the Second Circuit there said that that was transformative fair use. But here they're just giving away the entire book. There's nothing transformative about it. And so after 2 years, after the Internet Archive was sued, they apparently were doing discovery for 2 years, and we finally recently just got cross motions for summary judgment. And so the publishers argue that there's nothing transformative about recreating entire books and distributing them online. And on the fourth factor, they say this obviously, these are substitutes that usurp the market for the original. And of course, Internet Archive argues just the opposite. It says that CDL is just like for sale. It's just like what libraries have always done. They're loaning books. And this is totally transformative. Why? Because it expands utility and there's no effect whatsoever on the marketplace. And so these motions are pending. And I think the next round of briefs will be September 2nd. And in the meantime, a week after Internet Archive filed its motion for summary judgment, it had 6 amicus briefs that were filed at the district court level, all supporting it, all making pretty much the same arguments that this is transformative fair use. And obviously, this is really unusual at the district court level to even have one amicus brief and they had 6. So this is a very coordinated effort. But I think the main takeaway from all of this is that these things are for Congress to decide. And so proponents of digital first sale they're making a big push with the Internet Archive case. They're making a big push for state compulsory licensing. And so why aren't they going to Congress, right? So Congress is the only one who can actually do anything about either of these things. And so my own theory is it's simply because they know they're going to lose. Congress is never going to approve of these things because it would destroy the digital marketplace for ebooks. And so the reality is, we have copyright licensing because this is how authors and publishers make money. This is the incentives that they have to create and to distribute their works. And it's the reason why we have all of this amazing content. And honestly, to me, it's genuinely shocking that people look at all of this world where we have all this amazing content, all you can eat buffet for very reasonable price, and all of it legal. And they look at this and say copyright is completely broken. And to me, that's just shocking. So with that, I'll turn it back over.
All right, thank you. Thank you, Devlin, for that fantastic walkthrough of rights of distribution, reproduction, first sale, and all of those things. That was really helps, I think, sharpen a lot of people's knowledge on these topics. So next, we're going to go to Professor Adam Mossoff.
Thanks, Seth. And I view myself as just kind of serving as a supporting role for the incredible insights offered by Jesse and Devlin. I always learn so much when I listen to them speak on these topics, and I'm really grateful that the Free State Foundation, which I'm really honored to be a member of the Academic Board of Advisors, has invited them to speak on these important issues. And I'm just going to quickly kind of posit a couple of kind of broad framing issues because I really want to turn it back over to Devlin and to Jesse to kind of drill down into some more of these specifics, and to step back for a moment and to just to know for the people watching this and listening to this that, from most people, when you initially talk to them about copyright, the very first thing they say is, well, it's, copyright terms are so long, right? The terms are such an issue or such a problem, and there's some people in Congress who seem to think that these are issues as well. And yet notice none of this is being discussed in any of the actual active policy debates and discussions, because what really copyright is doing is facilitating and serving as a launching pad for how to facilitate market structures over new forms and methods by which copyrighted creativity, whether it's music, whether it's movies, whether it's books, is deployed in the marketplace and is put into the hands of consumers. And this was one of the great insights of the founders, was that they recognized that the way to do this is through property rights. Property rights grow societies, both its innovation economy, the creative industries, and help serve as the foundation for a flourishing society, as Randy mentioned. And so this is why they actually said, and James Madison said in Federalist number 43, right, that when it comes to patents and copyrights, right, that the public good fully coincides with the claims of individuals. So when Jesse was talking about balancing the interests, that what we're talking about is balancing the respective interests of the respective market participants. We are not talking about kind of trying to balance an inherent clash between the public good and copyright. Copyright serves the public good. There's tons of recognition of this by the Supreme Court and by the founders and by commentators going back over 200 years, because copyright, like a property right for a farmer and the fruits of their labors, or an industrialist, or any other type of worker or creator, that when you are secure someone in the fruits of their labors, they benefit themselves and they benefit society overall. And this is Adam Smith's great insight about the invisible hand. And so what you see then is that as society has developed, as the market has developed, as technologies have developed historically, whether it was player pianos and the turn of the 20th century, or and then radio, and then cassette tapes, or we remember 8-tracks and then cassette tapes, and then and what Jesse was referring to, the ancient history of dial-up, although Stranger Things has made people, I think, a little more aware of these things, in addition to bringing back awesome music and styles from the 80s, that that what Congress has been doing, and Devlin has mentioned that this is the role of Congress, because this is a federal regime, is to set up the frameworks to make it possible for property rights owners to engage with the new technologies, to engage with the relevant market participants, whether they're producers, distributors, retailers, whether they're internet service providers and wholesalers on the internet, and to create the market structures that get into the hands of consumers, the music, the books, the movies, and other types of incredible works. And in fact, as Devlin emphasized so well, we are overwhelmed with a massive amount of creative expression today as consumers, and is distributed through our society. And so it's really shocking to constantly hear people complain about our broken copyright system, how it's undermining the ability to access new works and create new works. And instead, in fact, what you have is the exact opposite. But what you do need is continual tweaking on the margins, as I think as Jesse highlighted, and what the SMART Act does is tries to align better the incentives of the relevant market participants, and to address this problem of holdout when participants have contrary incentives because of particular obligations that may flow to them from their participation in the sale and distribution of copyrighted works. Or as Devlin mentioned, there are efforts underway by many people in public interest organizations, and even by some companies, unfortunately, to undermine, weaken, or ultimately eliminate copyright in various ways. And they engage in and exploit sympathetic defendants or entities like public libraries, or the mom who happens to download 400 songs and wants to challenge the inability to access that work. And yet throughout all of this, the purpose, the goal of the copyright system, and the purpose, the goal of what Congress is trying to decide, and what the RIAA is doing, and what other participants are in the creative industries are doing, is actually driving not just the new creation of works, but also facilitating their distribution through the marketplace, whether it's digital, whether it's original tangible marketplaces, and whatever will be in the future. And I think that's kind of the important framework that we should always kind of retain and hold as the background context for the discussion of kind of these intricate details, where we start throwing around acronyms like CDL and STM and DTM and things of this sort. Copyright owners have joined the regulated industries and patent law with their love of acronyms, and so it's always important, I think, to remember that as my teacher, scholar, and mentor Richard Epstein reminded us constantly, the basics matter. So with that, I'll turn it back to Seth to continue the conversation with Jesse and Devlin.
Thank you, Adam, for that fantastic overview, that big picture, which you were able to tie to a lot of these issues that we have going. I want to pose a few questions on some of the topics that we've covered, and maybe get into a few others in the time that we have still. Jessica, I want to ask you a little bit more about the SMART Act, in particular the designated technical measures, the DMTs. It would call for the Copyright Office to engage in a kind of a process for identifying these things. Do you think the Copyright Office would have the chops to do something like this, both in terms of the courage and motivation to do it, and the administrative capacity? That seems a little different from the recording kinds of registration kinds of functions that we're certainly used to the Copyright Office doing. What do you think about that?
I absolutely do think that they would be able to run this type of survey and see what's in the marketplace. They don't need to invent a technical measure and come up with technology that is deemed sufficient by all the marketplace participants. They need to look at what's out there under this, see what all the participants are using for any given petition, and go from there. And they have at their access other agencies with expertise with whom they're supposed to consult. But this is the sort of decision or assessment that we ask judges to do every day, that the Copyright Office does in a 1201 context or other similar settings. So it doesn't, I think that there's a way to conceive of it that overcomplicates the technology underlying the STM or DTM, when really the role would be one of surveying and analyzing what's there, which is, I think, well within their capacity.
All right, let me just ask you a little, stick with you just one more time here on the issue of DMCA reform and maybe broadening a little bit. You'd mentioned the 2020 report by the Copyright Office when they talked about the balance of the DMCA being askew. Something that I noticed, and Free State Foundation President Randy May and we both noticed is, and the Copyright Office commented on this, is that the law had been interpreted in a way so as to make it harder to establish, for instance, secondary liability or vicarious liability, harder than the common law standards in terms of showing red flag or constructive knowledge of infringement, showing financial benefit, willful blindness, things like that. So there's the interpretive side, and there's also there was a Tillis Leahy draft bill on digital copyright, which would provide for a kind of a reform to the DMCA notice and takedown system by having a notice and stay down, so that if someone, a copyright owner, notifies YouTube, let's say that there's specific web pages that have their content, or they give them a representative list, that these providers, or certainly any major providers, should have to be able to take down similar content wherever it pops up thereafter. I mean, do you think there's a next best kind of DMCA reform? Just either something I've mentioned, something else that's out there?
So I think, what we've had is kind of a filtering effect from these reports and the initial piece of legislation that addressed a range of issues and then come down to STMs right now. There are certainly other areas where reform, in my view, would be beneficial, like you said, with red flag knowledge and willful blindness, clarifying that actual knowledge and red flag knowledge are distinct rather than conflating them as the same thing, as many courts have done. And notice and stay down, as you mentioned, being one of the proposals in that draft bill. It seems pretty rational and reasonable that if something should be taken down because it's infringing, it should stay down and then not pop right back up and require you to jump through the same hoops again. That would come down to implementation. The fine points are very important. And in terms of what's, in order to actually accomplish something in Congress these days, it's helpful to find areas that are discrete, that are achievable, that are politically viable, and where you can make progress, again, hopefully voluntarily and not having to get to Congress. And I do think there's many areas that are worthy of a further look, but I don't think now is the time when they would prevail, or I think the standard technical measure approach is a smart one, and one that can have a real impact, a real bang for its buck, while still acknowledging there's other issues out there that likewise are worthy.
Well, thank you. Devlin, I want to ask you a little bit about the ebooks. You had mentioned the court case out of Maryland, and that was a well-written decision. It focused a lot on Maryland's, the compulsory license aspect of the law in Maryland. So if you want to commercialize, have ebooks in your state, you've also got to, under this Maryland law that was preempted, you had to make it available to a library on certain terms. And the court really focused on the compulsory licensing aspect. We've heard some rumblings and seen some signs that the folks that want these restrictions on ebook licensing might just want to focus on the pricing in the future and just use state level rate controls. And you had talked about an exclusive right to of an author control, how and when their works are distributed. Does pricing fit into that how and when in that exclusive right?
That's a great question, Seth, and I should have mentioned that they're not done in the states, and in fact, the same people who proposed the Maryland bill, the same private actors who proposed it, have now revamped their thing and said, "Oh, okay, well, so the only problem was that they were forcing publishers to license to libraries. So now let's focus on the terms." And so, well, what was crazy about that to begin with was they defined it to be an unfair and deceptive trade practice just to refuse to license. And there was, I guess, a few years ago, a publisher who didn't want to license brand new releases immediately when they came out. They wanted to window their works, which copyright owners do. Why? Because it makes money, right? And there's absolutely nothing wrong with that. We like authors and publishers and copyright owners in general to experiment in the marketplace and to come up with ways that they can release their works and make the most money. And we're used to this, right? You get the initial premiere of a movie, a big black tie event, red carpet, the works, and then it goes to a few theaters, and then it opens nationwide, and then maybe you can do a digital rental, and then maybe a digital purpose, and then one day it's on DVD, and then it's like in the bargain bin at Walmart. Like we're used to this, right? And so the main problem was on its face. It was like you have to license to libraries, and the reality is they can choose not to. And so now, okay, they're past that. And now they're talking about, well, what can we do? And so here, I think that there is some room for states to say that you can't do something that is in fact, unfair trade practices. But I don't think price is one of them. The copyright owners under federal copyright law can set whatever price they want and charge whoever they want the price. And if you don't want to pay it, you don't pay it, right? So I think like that easily would be preempted just the same. There are some other things that I suppose it's imaginable that they would have some kind of practice that actually would raise some kind of problem, and the state could say, hey, you can't do that. But I don't think that price is one of them.
All right, terrific. Well, I think we're going to move beyond some of the topics that we've discussed so far, and maybe just touch on, even if only for a little bit, on some of the others that are out there. I would be interested in getting everyone's take, to the extent they're interested, in the American Law Institute's copyright restatement project. Many people are familiar with ALI and certainly this copyright project. I was a state court law clerk, for instance, and it was very common when I was the state Supreme Court that we would have cases that would involve questions of state law and the judicial interpretations, in quotes, judge-made law, case law. And sometimes that was even the question of the court. Are we going to adopt the restatement provision of the restatement of whatever? And so it's a little unusual to see ALI come out with a restatement on a subject that is federal statute. It's garnered a lot of controversy. I haven't really touched on this one, or we haven't at the Free State for a year or so, but I'd be interested certainly in your overall views, Jessica, starting with you, what you might have. And I'd like your take next after that, Adam. But your overall views, any concerns you might have about the ALI copyright restatement project? Yeah,
we are concerned about the project. Like you said, it's a statutory law, and a lot of what we've seen so far is blurring the lines between the statute and then the judicial interpretations that follow. And our concern is where it might bleed into policy preferences rather than where the law is and where the law is going. So we're concerned about bias and how it comes out, because, as you said, so many courts view it as a trustworthy, persuasive resource. And so we want to make sure that if it's viewed in that way, it's written fairly and represents the issues as they are, without putting its thumb on the scale in a way that might go against the interests of copyright owners and strong copyright protection, and toward a less favorable view of the right as a whole. We haven't seen a lot of the spicier chapters, haven't come out yet. We haven't seen what they say about fair use or the DMCA, but from what we have seen, we know that this is a project that to keep an eye on, and to be somewhat wary of, because it hasn't been representative of our view of what the copyright law is or where it is going.
Adam, do you have any insight on the ALI copyright project, or have any window into it? You're not a member of ALI, are you?
No, I'm not a member of the ALI.
Okay.
I mean, And but I share the concerns. I've expressed these publicly and in other contexts. So the restatement projects originally, were born in the 20th century, and they've always shared this. There's always been a tension in them between kind of just being purely descriptive, compilations of the common law to provide more efficient understandings for courts and as to how to apply the various doctrines that have been developed, and a more kind of prescriptive approach that some of the restatement projects have undertaken over the years. And in fact, there have been failed restatements that have engaged in too excessively prescriptive approaches in trying to push the law in ways that it hasn't been developed either in the courts or in legislatures. As Jesse rightly noted, it's very unusual. In fact, I think this is the only time there's been a restatement on a federal statutory regime. There are principles projects by the ALI that have addressed kind of federal statutory type regimes. But in the whole point, the principles projects are not to be restatements. They're not to provide kind of summaries and descriptive assessments of the law, but just to kind of identify underlying principles. And because at the get-go, this makes sense. I mean, why do you need a restatement when you have you do have a statement of the law? It's called the Federal Copyright Act. And so beyond just kind of those kind of superficial concerns, based upon kind of just the general structure of what restatements are supposed to do and how this conflicts with, having a restatement of federal copyright law. I mean, the genesis of this is well known. It's in an article that was published by Pam Samuelson, where she complained about the fact that she and her fellow copyright skeptics were not achieving the types of results that they wanted to achieve through either their lobbying of Congress or through their various litigation campaigns. And so they proposed this as an end run around both Congress and the courts as a way to try to influence the development of copyright in ways that, as I think Devlin kind of highlighted, would ultimately, minimize and diminish the ability of copyright owners and creators in the creative industries to secure the rewards of their productive labors by kind of portraying as part of the law what is in fact not the law, like controlled digital lending and things of that sort. So this is something to be watched very carefully. And from what I've heard, even the parts that have come out, as Jesse has said, we haven't seen the more spicier topics yet, but even the parts that have come out, there have been a lot of concerns about the framing of issues and some of the claims of the editors that are guiding the restatement project as to what actually is the rights of copyright owners and the rights of users vis-a-vis those copyright owners.
Devlin, I'd like to hear what you have to say about the ALI copyright project.
Thanks, Seth. So I kind of take a middle ground, and yet I've been watching this project from the beginning, and I do share a lot of concerns. I've heard a lot of people say, copyright is different. We have a comprehensive statutory scheme, and so why do we need a restatement? I personally think, I just look at it as another treatise, and take it or leave it. And, I love copyright treatises. So let's have one more. So what's the problem here? Well, behind the scenes, it's the reason many people who are pro-copyright are worried is because it's a situation of the fox guarding the hen house, as it were. And without mentioning specific people, there are people working on the project who are generally skeptical of copyright law and who seem like, maybe they wouldn't be the best people to write a treatise on copyright law that bears the imprimatur of the ALI. And so behind the scenes, I don't know if most people know this, but there has been huge pushback. And so every single time they release a draft, there are a lot of people who are reading it and making comments, and sometimes sections get reworked and sometimes they don't. I haven't followed it as much recently, but I've seen a lot of early drafts, and I didn't see like these outrageous things that were like they were trying to sneak one by or whatever. It was more just like death by 1,000 cuts, right? Like just these little things that add up. And so I'm not too worried about it. I know, like, even the Copyright Office came out and said that they're trying to create a shadow copyright law, which is kind of devastating. And but I'm confident that, you know, if there's something wrong in it, then people will point that out. It's not going to have this. It's not like the first restatement of property, or I guess that's a bad example. Adam would probably know that. But so, you know, I don't think it's going to have the weight that other restatements have, because those restatements take the law of 50 states and kind of condense it down into a black letter rule. So one of the biggest criticisms here with this restatement is the black letter rule is not the actual text of the statute, which like doesn't make a lot of sense to me, right? We don't have to condense down 50 states into one sentence. We could just go to the Copyright Act, and that should be the black letter rule. And lots of people have pointed this out. And as far as I know, they are not changing their minds on this. And so one example is in section, 102 of the Copyright Act. And it says that copyright protection subsists. And they refused in the black letter section to use the word subsist. And it's like, but it's like, these are terms of art, right? That word is controlling, and subsist is the actual law, but they don't want to use subsist. They come up with some other word. And so how is that helpful? It doesn't seem very helpful to me. And so, I mean, I'll point out that they're already releasing sections that can be used by courts right now. And so this is happening. It's going to continue to happen. As Jesse said, we haven't seen the most like the fair use part yet. And I feel like we're going to be hearing more about it once they start to release the things that are going to be more controversial. But for now, to me, it's a treatise. People are on the record for why we should be skeptical. And I don't think it's a terrible thing, but I don't think it's going to matter much either.
Thank you. Jessica, I want to ask you about a bill that's in Congress. It's called the American Music Fairness Act. It has to do with, of course, public performance rights and sound recordings.
Mm-hmm.
As many people know, when copyrighted music, sound recordings are played on your Spotify, on Sirius XM, you know, the copyright owners get royalties, but they don't for AM/FM radios when they're played. So this bill would address that, and I guess I want to get your take on it, because I think your industry has come on record, of course, as supporting the American Music Fairness Act. So what would your response be to the pushback that it's received that this bill would, in recognizing finally copyright full public performance rights for sound recording artists in AM/FM radio, that it would disrupt business relations, and that it's such a major change that there's no new underlying technology change that should prompt this. Those are some of the arguments I've had, and then it would amount to a tax as well. I would be interested in hearing your take.
Well, this issue has been kicking around for a long time, for decades. This bill, let's use the acronym AMFA while we're at it, because we love our acronyms, is the latest iteration of, as you said, modification of the public performance right for sound recording so that it would apply to all audio transmissions and not just digital audio transmissions. So, and like you said, the issue is when a song is played on the radio, AM, FM, the copyright owner for the sound recording, the artists, the labels don't get paid for it. The songwriters do on AM, FM radio, and then everybody gets paid every other way you listen to the song, including for the digital simulcast of the same radio program. So this bill would close that loophole, and the opposition has been the same, just as the objectives have been the same, because it would require payment where payment isn't required under current law. I think the characterization as a tax is just a deliberate decision to label a cost in that way in hopes of garnering sympathy, but it's a cost of doing business. And so that's, you know, if your business is playing music, you should pay for music. That's the thrust of what the law attempts to achieve fairness at, is saying there's no reason for terrestrial radio to have this sweetheart deal that nobody else does.
Now, would this bill, in fact, open up opportunities for, I've heard something about this, but could you confirm this? could this open up opportunities for American copyright owners to receive royalties from other countries? Because their songs are broadcast on radio stations all over the world. Many cases, American music is very popular. So it's not just a matter of American broadcast stations kicking in royalties, but would there be an open revenue stream internationally that American copyright owners are losing out on?
Yeah, so there's a lot. Most other countries have these policies of reciprocity. So if one country plays an artist from another country, they'll exchange the money for it, they'll exchange the revenues for it and pay you for it, so long as if the other country, they pay the artists back. So basically, I'll pay your guys if you pay my guys. And right now we aren't paying their guys. So this bill would change that dynamic and open up that reciprocity so that when American artists are played on the radio abroad, they would be eligible for the revenues from that performance.
Great. Adam and Devlin, I want to get each of your respective takes on the issue of state sovereign immunity in immunizing state governments from infringements, which has sort of prompted litigation raising a takings claim basis for recovery. In other words, if federal law, if the 11th Amendment bars copyright owners from collecting damages when their state governments or state officials infringe their works, you have copyright owners who are looking to raise takings clause claims using the 5th and 14th Amendment, saying it's a taking of property without just compensation. I'd be interested in both of your assessments of that theory, its coherence, and whether or not think that might catch on at some point in the courts. Adam?
I'd be happy for Devlin to go first.
Okay.
If you'd like to. That's
Devlin, I'd be glad to hear your take then. And Adam can think about it.
Well, Adam's the expert
he
on
might
it.
have.
But I'll go first, Adam. So it's disappointing what the Supreme Court said, because we had this section of the Copyright Act that said states do not get sovereign immunity. So the federal government, Congress, tried to explicitly take away immunity from the states, and the Supreme Court in Allen v. Cooper said you can't do that. It's not that you can't do it, you actually can do it. So Congress can take away sovereign immunity under the 14th Amendment. There's 3 Civil War amendments that gives Congress powers. And so, but you have to show that there's widespread infringement, widespread constitutional violations by the state. And so what's the violation? Well, what the Supreme Court says is if it's intentional, willful infringement by a state, then that is a constitutional deprivation of property. And so that's great. But when Congress passed that law years ago, they didn't have that kind of evidence. And so the Supreme Court said, well, get that kind of evidence, come back to us when you have it. Well, the Copyright Office did a study, and they found some infringements, but I don't think they found all of the infringements that are out there. And so we have this new study, this report of infringements by states, but it's not clear that these are intentional infringements, or if it's enough where if Congress were to try and abrogate state sovereign immunity again, that the court would say, good job, you've shown enough of a constitutional problem here that we're going to abrogate it. So we're kind of in the lurch on that. But what Seth, what you're asking about is, okay, forget about that. If the state violates your constitutional rights through a willful infringement, it doesn't matter whether there's abrogation by Congress. What the Supreme Court has said, and I think the case is Georgia, something, that if your rights are violated, then you can sue. And so we're starting to see people argue this and say, I don't need abrogation, I can sue the state. And I don't think we have any answers on this just yet, and maybe Adam knows a little bit more about that. But I think in theory it could work, and as a policy matter, I think it should work. I mean, why are we letting states willfully infringe people's copyrights? And so my take is that I think we're in the period where we're going to find out soon, but we don't exactly know yet.
Okay, Thanks, Devlin. And Adam, I'm going to try and press you on this. At the theoretical level, I mean, certainly in your background in patents, there is some recognition somewhere that a patent infringement could amount to a taking of a constitutionally recognized, cognizable taking of property without just compensation, isn't there? I mean, in theory, couldn't this be a viable claim?
Oh, not just in theory, in practice. So, I mean, so just, I mean, the founders put copyrights along with patents in the federal constitution. The very, you know, in fact, it's the only place in the entire constitution proper pre-bill of rights where the word exclusive right, the word right is used. You know, it was very clear that the founders at the time, the framers of the constitution, and then the Federalist period after that, you know, intended for to have a federal scheme for patents and copyright protection across the board, which would include the prohibition on the states from unauthorized using or taking copyrights or patents without authorization. And in fact, as I mentioned, in practice, this is exactly what you saw, at least in the patent space. There's a substantial number of federal court decisions from the 19th century where the federal court said this is a no-brainer. That, you know, where you had you know, the unauthorized use of patented inventions. A lot of it was in a military context, and one involved a post office use of an invention where they said, you know, hey, a patent is property. It's a property right on par with property, all other types of property rights, and the Constitution applies equally to all property rights. And it says, you know, nor shall private property be taken without just compensation, and therefore the government owes just compensation for this. And you know, one could argue, well, patents and copyrights are part of the same provision, so you know, by simpliciter, that treating like cases alike, you know, those types of decisions apply equally to copyright. You know, it's also, you know, it's a little odd for the states to be saying they should be allowed to, you know, get a free pass on the unauthorized use and infringement of copyright when they themselves can own copyright and they themselves sue for copyright infringement all the time. State agencies and public universities and other public entities at the state level do this. So this is an example, again, of where the system of our government is not that the government can, you know, should be able to have its cake and eat it too when it comes to the, you know, use and or abuse of the products of individual citizens. You know, so if the states can get the benefit of copyright, they should be held accountable for copyright infringement as well. And you know, there's a cert petition before the U.S. Supreme Court right now on this issue out of Texas. Involving Texas A&M's unauthorized disclosure for its own benefit of a copyrighted work by an author, Michael Bynum, on the 12th Man, which is a great football legend out of story out of Texas. You know, but I am concerned the Supreme Court won't see this for what it should, especially because you have justices like Justice Thomas and others who normally would recognize that the same types of protections accorded to copyright and patent owners and other property owners under the Fifth Amendment should be accorded to, you know, it should be applied in the same way that all rights are protected under the Bill of Rights. He unfortunately has in other contexts has signaled very strongly that he doesn't believe that patents and copyrights are private rights. That they are accorded valid protections under either the 14th Amendment or the Bill of Rights, or under the separation of powers doctrines more broadly. And so I would be worried that if this case was actually brought before the U.S. Supreme Court, the Supreme Court would do something similar to what it's done in the patent context recently in decisions by Justice Thomas himself, where they have denied constitutional protections to intellectual property rights. So I think this is an easy case. It's a no-brainer. You know, there's historical decisions by federal courts, including the U.S. Supreme Court in the 19th century on these issues. Unfortunately, you know, you have a combining of the left and the right on the court with this view of patents as monopoly grants or as these special privilege grants that aren't accorded constitutional protections. And so I think that, you know, it's not necessarily an easy argument to make. In fact, I think it's an uphill argument to make if you're going to go to the court today.
All right, thanks, Adam. One last question, if you can just take just a moment, just a minute or two at most, Devlin. The Copyright Small Claims Tribunal just got underway. I'm wondering if you have any insights or hopes or views about that.
Devlin,
well,
just really do take a moment on that, because we want to end up on time to respect our audience.
Well, then I'll just briefly say that I think it's a wonderful thing. It'll finally mean that regular people who have their rights infringed can actually get some kind of remedy for that infringement. And that's the problem with copyright infringement. You have to go to federal court. It costs thousands and thousands of dollars. People can't do that. We now have a small claims tribunal where you and me and regular people can go and hopefully get some relief. So I have great hopes for it. And I think the Copyright Office is doing a wonderful job with it.
Terrific. Thank you.
That truly was just a moment, and we appreciate that. But most of all, we really appreciate having this expert panel with us today. And Seth, thank you for moderating. It's clear we could have gone on for another hour or two, but it's good to save some for next time. So we'll do it. We'll do it again. The way I want to really close is this, following up on what Adam said, and he said it eloquently a couple times, really, when he was putting these issues in a broader frame, because as important as they are today, all the things we talked about, and they're really important when you think about the foundational principles, what we here at the Free State Foundation referred to as first principles often. And that's the reason why in our book, we referred to the constitutional foundations, referring to foundational principles. And, Adam put it nicely, but I want to really end up this way. It'll give me a chance to read from the book one more time in closing. But I mentioned earlier that we started with John Locke in this book and sort of traced intellectually the intellectual history of securing property rights from a foundational point of view, right up to Abe Lincoln. People don't often, Lincoln did, so much in other contexts that were important that we don't think of Abraham Lincoln really in terms of intellectual property rights. But the way he talked about intellectual property rights was not really unrelated, right, to the way he thought about free labor, really, and freedom in this country. And so what I want to do is just close by reading a couple excerpts from what Lincoln said, because I always like to quote Lincoln when I have an opportunity. So this is from one of his speeches in 1847, going back then. Lincoln said, well, each individual is naturally entitled to do as he pleases with himself and the fruit of his labor. I always thought the man that made the corn should eat the corn. That's a pretty layman-like way of understanding that principle, the principle of protecting the fruits of your labor. And then finally, in 1864, in a well-known speech to the New York Working Men's Association, Lincoln said this: property is the fruit of labor. Property is desirable, is a positive good in the world. That some should be rich shows that others may become rich, and hence is just encouragement to industry and enterprise. Let not him who is houseless pull down the house of another, but let him labor diligently and build one for himself. Now, when you think about it, I know that's a very broad way of thinking about first principles, but it's not unrelated, I submit, to a lot of what we were discussing today, and why those issues we were talking about today ought to be resolved in favor of securing property rights. So with that, again, I want to thank this panel. It was terrific. I hope we saved some to do it again. We'll do it again anyway. It was great. So thank you all. And I'm going to close out our session, and we'll see everybody soon. Bye-bye.